Taryn versus Andrew Cuomo is one that we came out with right after the SAFE Act passed. You're all very familiar with the New York State Rifle and Pistol Association case. And for as much as people that I've heard over the last couple of years complaining about the NRA and they're not doing anything in New York, they have spent almost $750,000 on that case to date. But this was concurrent with that case. But rather than having a very broad-based case the way the Rifle and Pistol Association, this was very narrow, tailored, on a single issue. We felt it was the low-hanging fruit we could pick off on the 7 and 10 round magazine restriction. After this case was not decided until after the ruling from Judge Scretany in the Western District Federal Court, and one of the things that he ruled was that that 7 and the 10 round magazine was unconstitutional. At that point, there were some DAs around the state saying, well, that only counts in the Western District, doesn't count in the whole state. That's bull. I'll tell you that straight out. The only way that it doesn't count for the whole state is if you have a competing ruling in a different district. And immediately when they started saying that, we put out a press release and put out specific case histories or cases that showed that that was not the case. But since there was some confusion on that, we continued forward with that case, and on March 31st of last year, we came to an agreement, a stipulation from the Attorney General's office that we would stay the case with the stipulation that New York State will issue instructions to all state agencies, not just the state police, but every state agency that that ruling in the Western District Federal Court applies to the entire state. So no state agency will attempt to arrest anybody for having more than 7 rounds in their magazine. If they were to go back on that case hasn't been withdrawn, it's just stayed. So that could potentially be reactivated.